I'm not, things don't stop here. Kindly have a look to the Honorable Supreme Court's order, not when your Lordship's order is not quoted while being upheld. Page 9 of the order.
We gave it on the last day, but
Yes, it's
I've
available.
given another copy, my lord. My lord, need
The front.
Should I get it?
আচ্ছা পেয়েছেন যত তো
কি should I get it?
ক্যাপ্টেনকে না দিলে হবে
Page 9.
You give that. Supreme Court. Page 9.
Page 9. Kindly have a look at not the second line from the top of that page. It is in the above background that the direction was issued to the State Election Commission to send the requisition for deployment of the central forces in areas which, in the opinion of the State Election Commission, had been declared as sensitive forthwith. Therefore, we find that it was directed in the earlier order that there must be identification of the sensitive districts. But bearing in mind the fact that the State Election Commission had not complied with the earlier directions of the High Court in identifying the sensitive areas, we find that the High Court was left with no option but to direct the State Election Commission to requisition the deployment of central paramilitary forces for the entire state. When the observations in para 16 of the impugned order dated 15 June 2023 are viewed in light of the earlier order of the High Court not being complied with, we do not think they are unjustified. In fact, the directions issued by the High Court must be viewed from the point of view of the electorate of West Bengal, who should be enabled to exercise their franchise in a free and fair manner and not be in fear of the safety of their life and property. Kindly skips over the 3 lines of the next paragraph. Moreover, the state is conducting local body election on a single date. The High Court has also based its decision after considering the number of seats which are going to the polls and the volume of polling booths that are being set up for holding the said polls. Kindly turns over to page 11 now. The 5th line from the top of that page. 4th line. Therefore, in our view, the High Court was not in error in issuing the aforesaid directions, as the same was done to ensure not only that the nominations are filed in a peaceful manner, but also that the entire election is conducted fairly and the results are declared peacefully. Now, your Lordship's desire was from the stage of nomination, not the observation is there in the first order, nominations, withdrawal, all these things were taken into consideration, forming the basis for the loss of time being taken care of, with immediate proactive steps to be taken by the Commission, which ultimately resulted in irretrievable forfeiture of the trust and confidence which the Court of Justice reposed on the Commission. And that's reflected in the last order passed by this Honorable Court on 21st of June 2023. Now, I'll just read 2 sentences from your Lordship's last order. Sir. At page 3. Page 3, paragraph 3. আগের অর্ডারটা After elaborately hearing the arguments of the learned counsel for paragraph 3 for the parties, we have no hesitation in our mind to hold that the order and direction has not been complied with in its letter and spirit. We fail to understand as to why the State Election Commission is still not taking any independent decision in the matter, and the learned senior counsel for the State Commission on Instruction stated that the Election Commission will abide by the directions issued by this court. In the first order passed by this court, the court reposed confidence on the State Election Commission and directed to make an assessment of the sensitive districts. But we found that this direction has not yet been taken and the matter was being dragged, which necessitated the court to issue direction for deployment of the central forces for the entire state, which order has been also affirmed by the Honorable Supreme Court. On instructions, the learned senior advocate for the State Election Commission submitted that one company of the central forces, but I need not trouble your lordship with the number of personnel. Lordship may straightway come to note the 8th line from the bottom of that page, beginning with the sentence beginning with the words, if that was the manner after the 2013 Panchayat election was considered. If that was the manner in which the State Election Commission had acted in the year 2013, we are at a loss to understand as to what has happened to the independence and supremacy of the State Election Commission during the ensuing election. In the said order of the Honorable Supreme Court, it has been recorded that the Panchayat election 2013 was to be conducted in 5 phases from 11 July to 25th July 2013. And interestingly, deployment of state police force was 1,05,000 and central forces was 82,000. And more particularly, at the relevant point of time, there were only 17 districts in the state of West Bengal, as against 22 districts at present. Therefore, if the State Election Commission is not proactive and not inclined to implement the order passed by this court in its letter and spirit, we are of the prima facie opinion that the State Election Commission is attempting to make the orders passed by this court unworkable, to which they are not entitled to, more particularly when the Honorable Supreme Court has affirmed the order. This will also lead us to a prima facie conclusion that there has been deliberate violation of the order and direction which was directed to be complied with in its letter and spirit in the light of the submissions made by the learned senior counsel for the commission, and the commission will abide by the directions issued by this court. We are inclined to issue the following directions, which are ancillary and supplementary to the orders passed in the earlier 2 writ petitions. The State Commission shall, within 24 hours, requisition sufficient number of central forces to be deployed to all the districts, and the number of battalions which are to be requisitioned shall not be less than the forces which was requisitioned for the 2013 election, and it has to be definitely more than the same as the number of districts have increased, and the electorate would be definitely increased between 2013 and 2023 in these 10 years. Therefore, we expect that the State Election Commission to take note of this direction in a proper and effective manner, and this court hopes that the direction will be complied with in its letter and spirit, and any attempt to make the order unworkable may result in adverse consequences. But it's the final caution, not in my most respectful submission, given to the Commission. Then not kindly sees not paragraph 5, which makes a more distressed and not awful reading of the conduct of the authorities. It is pointed out by the learned counsel for the petitioner that in the specially petition filed before the Honorable Supreme Court, a copy of the letter addressed by the Additional Chief Secretary, Home and Hill Affairs Department, Parliamentary Affairs, to the Principal Secretary, Department of Home Affairs and Justice, Government of Punjab, dated 12th of June 2023 was annexed. On going through the letter, we are surprised to note that the requisition which was made to the Government of Punjab was to provide police force to reach the designated location by 6 July 2013 morning. Then not, your lordship has been please turn over to the next page. Or not the last line of that page. Surprisingly, the sentence beginning from the extreme right hand side of the line.
Yes.
Surprisingly, the instructions given to the learned senior counsel for the State Election Commission is contrary what has been written by the Additional Secretary to the Government of West Bengal to the Principal Secretary, Department of Home Affairs on 12 June 2023. This also appears to be an attempt to mislead the court, as the court, even in the order passed in the earlier petition, had made it clear that the requisition of the central forces was to cover the entire election process, not on the date of polling alone. Therefore, we are of the view that such deployment of the forces from other states to be in place on the date of polling will not yield the desired result. Therefore, dehors the number of police forces which may have been requisitioned from other states. The State Election Commission shall independently assess the requirement, and as observed earlier, the assessment should be honest and bearing in mind that the State Election Commission has constitutional obligation to ensure free and fair election and to preserve the purity of the entire election process. Similarly, it's not only free and fair, but also the purity of the entire election process. And when not the materials placed on record before your lordships clearly point at loss of or not lack of independence, lack of proactiveness, willful slackness, coupled with not the action of 12 June 2023, as expressed by the Government of West Bengal, I am sure your lordships will be more than persuaded to hold that this has been a deliberate attempt to sidetrack your lordship's order, for which further ancillary orders are required to be passed, Not it's common knowledge, not even yesterday or day before yesterday, not the court had to observe that the video was aiding a particular political party. Not there has been withdrawal of 5,000 nominations.
Foreigner is a nomination.
A foreigner has submitted a nomination.
Staying in Saudi.
Now, these are glaring facts which the court cannot lose sight of.
We will hear the commission what they will have to say.
Not, I just renew my prayer. Not kindly have a look at your lordship's first order. On 13th June. Not on 9th June, not we from the array of parties we struck off the state election commissioner in his personal capacity. Please have a look at paragraph 41 of your lordship's order at page 22. By tinkering with time, the essence of your lordship's order has been gravely undermined. Paragraph 41 at page 22. The next issue is with regard to the appointment of observers. The State Election Commission has submitted that it appoints observers from senior officers of WBCS executives and IS cadres, and the appointment is made following the stipulation in section 134 of the Act, hereinafter so and so. This response is to the prayer sought for by the writ petitioner in WPA to appoint a retired judge of this court as an observer to ensure conduct of free, fair, transparent and peaceful election to the 3-tier Gram Panchayats in the state of West Bengal. Section 134 falls in chapter 16 of 2003 Act. Subsection 1 of section 134 states that the commission may nominate an observer who shall be an officer of the state government to watch the conduct of election or elections in the constituency or group of constituencies and to perform such other functions as may be entrusted to him by the commission. Subsection 2 states that the observer nominated under subsection 1 of section 134 shall have the power to direct the Panchayat returning officer for the constituency or for any other constituencies for which he has been nominated to stop the counting of votes at any time before the declaration of the result or not to declare the same if in the opinion of the observer booth capturing has taken place or at a large number of polling stations or at places fixed for counting of votes of many ballot papers used at a polling stations are unlawfully taken out of the custody of the Panchayat returning officer or are accidentally or intentionally destroyed or lost or damaged or tampered with to such an extent that the result of the polling at the polling station cannot be ascertained. Subsection 3 of section 134 states that where an observer has been directed the Panchayat returning officer to stop counting of votes or not to declare the result, the observer shall forthwith report the matter to the commission and thereupon the commission shall, after taking all material circumstances into account, issue appropriate direction. Thus, the statutory provision clearly provides for nominating an observer by the commission who shall be an officer of the state government to watch the conduct of the elections. The State Election Commission in its report has stated that the commission appoints observers from the cadre of senior officers. I'm sorry.
Please carry on.
From the cadre of senior officers of the West Bengal Civil Services and IAS cadres. In our opinion, the exercise to be done by the State Commission being in accordance with the statutory provision, the court will not be justified in interdicting the same as the senior officers of the West Bengal Civil Services as well as the officers in the IAS cadres are bound to act with due diligence, bearing in mind the purpose for which they have been nominated as observers. Now, please take the last 5 lines of that page, particular page. But I need not trouble your lordship with the rest of the paragraph note, which may not be very necessary for our purpose at this stage. Therefore, we are of the view that your lordships have kindly got that the appointment of observers from the senior officers of the West Bengal Civil Services executives and IS cadres is in consonance with section 134 of the 2003 Act, and the same would be sufficient safeguard to achieve the object for having free and fair elections, maintaining its purity. Therefore, we see no reason to accede to the prayer sought for by the writ petitioner to appoint a retired judge of this court as observer for the ensuring election. So, my lord, with the passage of time and my lord, the conduct gleaned from the action or my lord, the materials available on record, it is clear that the independence and supremacy of the commission has been surrendered for any unholy purpose. And my lord, I am not mincing any word for this purpose when I am advancing my submission. The essence of time, the spirit of the order has been frustrated. Number one, your lordships have been more than persuaded to hold that the supremacy and independence of the commission has been surrendered or is questionable. Your lordships have been prima facie pleased to hold that the commission is guilty of contempt for sidestepping your lordship's order in letter and spirit. And the authorities have misled the court. When your lordships were persuaded to repose trust and confidence in the first order of 13th of June 2023, your lordships were misled. So the changed circumstances encourages me to renew my prayer, even if it is not through a retired judge. It's common knowledge. His Excellency, the Honorable Governor, is not accepting his joining.
It is returned.
Not only by the highest judiciary of the state, but also the executive head of the state is not reposing confidence. But are we to sit tight as mere onlookers? But I am renewing my prayer insofar as appointment of observers is concerned.
So the order is complied with observer.
Yes.
So the order is complied.
That the purity of election is one of the essential factors which had been taken note by the judiciary. Free and fair election and purity of election. This purity of election has been compromised at the behest of the commission. And there are sufficient reasons to be indicated in the last paragraph page of your lordship's last order in the contempt jurisdiction. This is one aspect of the matter. So far as deployment of forces is concerned, the election commission, the state and the center is before your lordship's court. Today, with the passage of time, with the uncanny situation which prompted withdrawal of 5,000 nomination on one particular or 2 or 3 particular dates. I can give the list of the political parties who have been forced to. 40,000 nomination submitted on a particular day for the ruling party in dispensation, and 5,000 nomination withdrawn.
In 1 hour.
Within 1 hour, 40,000 nominations submitted.
They submitted extra and withdrew
it. Somebody from Saudi Arabia had filed the nomination. That's in the court's jurisdiction now.
The order passed. That is not.
Court has passed orders.
We are not getting that order. It's not uploaded. File can be repeated. WPA number দিয়ে দিচ্ছি আমি 1481 আবার চেক কর
20,585 withdrawal
in 4 days 17 থেকে 3 দিন
in 3 days.
নিজেরাই বেশি করিয়ে তারপরে আবার
essence of time was the time was the essence of the order, and which they have not successfully eroded. With the questionable conduct of the commissioner, with the complete forfeiture of trust and confidence which the court reposed on the commission, I submit there should be an appointment of an observer, number one. Number two, so far as conduct of election is concerned, your lordships may also consider the 2013 situation when the court directed, not because of non-deployment of forces in 5 phases or on 5 days, the lordships may reconsider the issue. These are my submissions.
Yes. Yes.
Now, my lord, we are in a contempt jurisdiction. I cannot say that I am not going to obey the orders of the court. My learned friend's client has certain grievances which is brought to the notice of the court as an informant to the court. Milord, today the final submission is that observers are required to be appointed by this court. But I'll come to that later on. My first submission would be, Milord, on the contempt aspect. Milord, the final order in the series of order has been passed by the Honorable Supreme Court prior to the last order of this Honorable Court. Now, please have a look to this order, Milord, which my learned friends have handed up to the court. Yes. Milord, please take the third page of the order. But these are all, Milord, quoting my lord's order initially. Please take the third page of the order, but after the quoted portion. Thus, by issuance of the aforesaid direction, the State Election Commission was directed to requisition the deployment of central forces, and the direction was to be complied with within a period of 48 hours from the receipt of the copy of the order. There were other orders on 9th of June and 13th of June. Then, Milord, the Honorable Supreme Court, Milord, quotes those orders. Then please take, Milord, page 6. Learned Senior Counsel appearing for the State Election Commission as well as the State of West Bengal contended that direction for requisition of the deployment of the central forces for all the districts in the State of West Bengal was wholly unwarranted, and therefore the same ought to be interfered with by this court. More particularly, the Learned Senior Counsel, Mrs. Meenakshi Arora, contended that it is not within the jurisdiction of the State Election Commission to requisition the deployment of the central forces for the conduct of election in the state. Learned Senior Counsel appearing for the State of West Bengal also submitted that no doubt there may arise a need for additional police forces for the conduct of a free and fair poll on 8th of July and for the processes leading up to the said date. However, the additional forces to be summoned or requisitioned is a matter within the discretion of the state government. The state government, in addition to the police forces already under its command, could requisition or plan to requisition the forces from the neighboring states. But the impugned direction, which has been issued by the High Court, has taken away that discretion, and hence he submitted that the said direction ought to be quashed. These are the submissions of the Commission and the state. Now, Mr. Harish Salve was representing my learned friend's client. Par contra, Sri Harish Salve, Learned Senior Counsel appearing for the respondent number 1 on caveat, supported the order of the High Court and submitted that this is not the first time that the High Court has issued such a direction. Even on previous occasions, similar directions have been passed by the High Court in order to ensure that free and fair polls are conducted in the state. It was further submitted that in the instant case, having regard to the earlier directions issued by the High Court not being complied with by the State Election Commission, the observations at paragraph 16 were made, and therefore the consequent direction at paragraph 17 does not call for any interference in this special petition. Then, Milord, we give our reply. Then please skip over the next paragraph and the paragraph thereafter. We have considered the submissions made on behalf of the rival parties and given our anxious consideration to each of those submissions. It is significant to note that members belonging to different political parties have voiced a common concern and had sought similar reliefs in the writ petition filed before the High Court. At the outset, we find that the order dated 15/6/23 for deployment of central forces for all the districts in the state of West Bengal has been preceded by earlier orders passed by the High Court, which we have referred to herein above. In the order dated 15th of June, the High Court has noted that earlier a direction was issued to the State Election Commission to review the assessment plan submitted by the state, and wherever there was inadequacy of the state police, the State Election Commission in all such areas was to requisition the deployment of paramilitary forces forthwith, and on receipt of such a request, the appropriate authorities of the central government were directed to deploy the required strength on charges to be borne by the central government. However, the State Election Commission failed to identify these sensitive areas, and as observed by the High Court, The State Election Commission has not requisitioned the deployment of central forces till the writ application were heard finally. It is further observed by the High Court that there was no due diligence in the implementation of the directions issued by the High Court in the earlier writ petition in its letter and spirit. Considering the sensitivity of the issue, the High Court noted that the State Election Commission had dragged its feet in not complying with the direction of the High Court, even though a decision was taken in a meeting of 9th June for identification of the sensitive areas from the point of view of law and order. In the light of the above observation, the High Court finally concluded at paragraph 16 as quoted above and issued the directions at paragraph 17 of the order. It is relevant to observe that it is not for the first time that a direction for deployment of central military forces has been ordered by the High Court. In paragraph 48 of the order dated 13th of June, there is a discussion on the earlier occasions in which the High Court had directed the deployment of paramilitary forces as and when the situation so demanded. It is in the above background that the direction was issued to the State Election Commission to send the requisition for deployment of central forces in the area, which in the opinion of the State Election Commission had been declared as sensitive forthwith. Therefore, we find that it was directed in the earlier order that there must be identification of the sensitive districts, but bearing in mind that the fact that the State Election Commission had not complied with the earlier directions of the High Court in identifying the sensitive areas, we find that the High Court was left with no option but to direct the State Election Commission to requisition the deployment of central paramilitary forces for the entire state. When the observations in para 16 of the impugned order dated 15/6/23 are viewed in the light of the earlier of the High Court not being complied with, we do not think they are unjustified. In fact, the directions issued by the High Court must be viewed from the point of view of the electorate of West Bengal, who should be enabled to exercise their franchise in a free and fair manner and not in fear of safety of their life and property. Fact remains that the tenor of the order of the High Court is ultimately to ensure that there is free and fair election conducted in the state of West Bengal. Moreover, the state is conducting local body election in a single day. The High Court has also based its direction after considering the number of seats which are going to the polls and the volume of polling booths that are being set up for holding these 8 polls. It is needless to observe that the central force would act in an appropriate manner, bearing in mind the emerging situations and for aiding in a free and fair conduct of the election. We further observe that portion, I don't think is that relevant for our purpose. Kindly take page 11, the first paragraph. The endeavor of the respondents, writ petitioners before the High Court appears to be to ensure free and fair election to the local bodies in the state of West Bengal. This would strengthen Panchayat Raj institutions in the state. Therefore, in our view, the High Court was not in error in issuing the aforesaid directions, as the same was done to ensure not only that the nominations are filed in a peaceful manner, but also that the entire election is conducted fairly and the results are declared peacefully. We also take note of the fact that the respondents hearing or the petitioners before the High Court, although affiliated to different political parties, are united. Therefore, finally, the Supreme Court, on 20th of June, directs or dismisses the specially petitions by upholding my lord's order.
Yes.
Now, on the issue of contempt, may I humbly submit, this order was delivered by the Honorable Supreme Court on 20th of June. On 22nd of June, copy that. So the first page is the requisition from the State Election Commission to Ajay Kumar Bhalla, etc. Enclosed please find with herewith communication from the State Election Commission regarding so and so. The next page, the letter is there. Panchayat elections have been notified in the West Bengal by the State Election Commission. The Honorable Calcutta High Court has ordered the State Election Commission West Bengal to requisition and deploy CAPF in the state reference. The Commission accordingly approaches you to kindly mobilize 800 companies of CAPF for the state. The forces will report to the district magistrate and district Panchayat election officer of the district district-wise breakup was as follows. Breakup follows, I'm sorry. It may be noted that the current requirement is over and above the 22 companies already mobilized for the State Video Commission's communication dated 20th of June 2023. Therefore, my lord, as of now, 800 plus 22, my lord, companies of CAPF has been requisitioned. My lord, we are yet to, my lord, receive any response from the center.
Response has been obtained from the main check. 315 is coming, 315. As for, so there is a list of 485 companies, and for that also a requisition has been issued to the Ministry of Home Affairs today itself. I'm giving you the copy.
My lord, while my lord, this matter was going on, before the start of the matter, my lord, my instruction was there is no response. But right now, my lord, I'm told that out of 800 companies, 315 has been sanctioned, my lord. They may reach at any time. And so far as the balance, 485.
Letter has been issued from the Commissioner today itself to the Ministry of Home Affairs.
Another letter has been sent while, my lord, this proceeding was going on. Today itself, during the course of this proceeding, for, my lord, releasing the balance 485 companies. So, my lord, these are the figures, my lord, for your lordships, my lord, for the present. Therefore, my lord, I very humbly submit that, my lord, as soon as, my lord, our last persuasion was over before the Honorable Supreme Court, my lord, we have done it, my lord, within 48 hours. This is, my lord, so far as, my lord, requisitioning of the force is concerned. My lord, we are expecting the central government to, my lord, act in terms of your lordship's order, my lord. Thereafter, my lord, once they come, my lord, the deployment would be taken, would be made. Therefore, my lord, I would be very respectfully submitting, my lord, that in view of, my lord, the hierarchy of our judiciary and, my lord, our exercise of right, my lord, there is no willful delay on our part, my lord, in requisitioning the police force. I mean, the central forces. Now, my lord, on the apprehension,
Yes,
and my lord, I must also, my lord, say that, my lord, if your lordships would kindly consider that, my lord, there was no deliberate violation, my lord, on our part, and therefore kindly, my lord, drop the proceedings. My lord, this would be, my lord, my first submissions, my lord, in respect of the deployment aspect only.
yes,
Now, my lord, on the other aspect that the free and fair elections are concerned, my lord, we can only, my lord, tell the court that it is our obligation, and we would try to, my lord, to the best of our ability to, my lord, ensure that there is free and fair elections. My lord, the incidents which my learned friends have said, my lord, these are all incidents, my lord, which are being taken care of, my lord, in the adversarial side, my lord, where party or the persons who feel that they could not approach the court, I mean the nomination filing centers within time, or nomination has not been considered accordingly, my lord, they are pursuing their remedies before the appropriate court in the adversarial side. Now, my lord, on the aspect of observers, my lord, may I only say, my lord, one more thing, but I think, my lord, this figure should also be placed before my lord. My lord, as your lordships have been informed, my lord, in 2013, my lord, the elections were held in 5 phases. Now, my lord, in each of the phases, my lord, I think, my lord, we should give the number of, my lord, which were deployed. My lord, in the first phase, 15,000 were deployed.
yes, that's there in the Supreme Court.
Yes, very well. So, my lord, I don't, my lord, repeat what is there before the Honorable Supreme Court. Now, my lord, on the other aspect which my learned friend says that, my lord, observers are to be appointed. But on that, my lord, I think, my lord, it is too premature at this stage to make this kind of a prayer. My lord, we are committed. We have got a constitutional responsibility, my lord. We are a constitutional body. The head of the constitutional body is having, my lord, all plenary powers, my lord, as have been held by the Supreme Court, by, my lord, interpreting the expression superintendence and control of election. My lord, we can, my lord, only tell this honorable court, my lord, that we will take all steps required, necessary, my lord, for free and fair elections, my lord. My lord, and so far as, my lord, the observers are concerned, I think, my lord, it is too premature at this stage, my lord, to ask for this. My lord, whatever were the apprehensions were, my lord, so long on the anvil of the anxiety to have the central forces. Now that the central forces are in place, my lord, we have abided by your lordship's order. My lord, so kindly, my lord, on the observers aspect, my lord, kindly, my lord, do not pass any orders, my lord. And if your lordships consider that it is required to be passed, but in that case, my lord, let my learned friends.
Appointed 273 observers from West Bengal Civil Service Executive Cadre and 22 officers.
Under which power have we? 73 IAS.
73.
Only 22.
Special observers. for instance.
Excellent. Who's 273?
That's 22. 273.
WBCS.
Right. sir.
আর এরা হচ্ছে আইএস আর কি করেছি
বলা হয়েছে কোনো পর্যন্ত।
Yes,
Milord, on the observers aspect, Milord, my instructing officer says that, Milord, we have already appointed, but I have to check up those provisions. But right now, Milord, I'll be very candid, Milord, I'm not having those provisions with me. 273 WBCS officers, Milord, has already been appointed as observers, and 22 IAS officers have been appointed as observers.
this 273 are in group 1 officers.
Yes, yes.
What will be their cadre roughly?
The cadre group 1 officers.
হ্যাঁ, WBC is executive.
অনেকগুলো তো
WBC is officers. Will be a good service. Combination of present there till the completion of evaluation form 7 of the contesting candidates.
Right.
They have been there.
Well, these are all Milord class 1 officers.
Class 1.
And Milord, their deployment is till the declaration of the results.
But there is no report, no affidavit on behalf of the commission.
Milord,
Misconduct.
I'm sorry, Milord.
That is, we passed an order on 21st June,
Yes, Milord.
and pursuant to that, there is no report filed by the commission.
Before this court.
Yes. Before us,
I don't think so, Milord. I was not there. আমরা এখানে কোনো রিপোর্ট ফাইল করেছি Milord, we can file report, Milord. We have not filed a report as yet, Milord, with all these
but it should be in the form of an affidavit. So we'll frame an order now. We'll
But
see.
may I say this, Milord? I have got nothing to hide from the court. Whatever I give,
No,
Milord,
let it go on record. That's better.
wait.
Because they have filed a contempt alleging willful delay.
Yes.
Now the explanation of the commission is post decision of the Honorable Supreme Court on 20th of June, we have complied with. But their submission appears to be the delay should not be computed from that date. The delay starts running from 13/6
Right.
from the first order.
Right.
So that is one aspect we need to consider. And then what about the other incidents? The thing is, we don't know. Of course, obviously they should have a control room. They should have to monitor the entire activity throughout the state 24/7. Anything can happen. Nomination, how they have just been filed, periodic reports. We don't know what is the machinery you have set up because Even in the first writ petition, second writ petition, contempt petition, nothing has been disclosed to us. Except for one, we have in fact, in the first order, we have noted that in an unsigned, undated report was placed, which we took into consideration because submitted through a senior advocate along with annexures, we took it as. So that's been the stand of the commission. We don't know how the commission files. Even today, one matter in the other division bench, we have disposed it of directing the commission to look into the matter. In another matter, commission has been directed to submit a report on Monday, where there has been 275 seats. Nobody has filed nominations except one set of candidates, and it is going to go uncontested. What is that block? What is that block? Canning one block. So that we have said. And who has come to court? Not the candidate. The people who say I am the electorate, my right to choose a candidate is being lost. It is done in an undemocratic manner, etc., etc. So, speaking for myself, I have done such matters where what happens is on a real-time basis, the commission is in touch with the standing council. Reports are being sent by email or in soft form, and they will say, "This is my structure." That's how they were always on plain paper, but we don't know how the commission has been put. And we don't want to go into the other issue which he has pointed out.
Yes.
So we'll make an order. Let us see what happens.
Kindly, my lord, not to be taken on record.
Ah.
But at one point of time, my lord, I had made an assessment as to in the Panchayat, well, what is the situation in the other part of the country? My lord, in many states, the statistics are in the Panchayat rung, quite a large number of seats go uncontested. Because it is mostly within the village, people know each other.
I don't know whether they have all come to court, etc.
Yes.
Anyway, it may be a true or may not be true. We'll hear the additions also.
Yes.
Thank you.
But yesterday evening, the Home Secretariat had a discussion with me. Yes, I'm sorry. Yesterday in the evening, the Home Secretariat of Government of India had a detailed discussion with me. Firstly, they desired that the 2013 model may be followed, and if it is followed, that will be convenient for the Home Ministry to deploy the entire forces. Now, at night, I have received an instruction for perusal of your losses. This is the instruction I have received. It is addressed to me personally, but it's an instruction. Now, lordships kindly find from para 2, the deployment of forces in 2013. It has given a breakup and other things. Now, if my lords kindly come to the next page.
So the 315 companies.
315 plus 22 already
Acquisition. And this will be more than 2030.
Yes, that has been reflected in para 2 of the instruction.
Yes, which is higher.
Para 3 of the instruction.
Para 6 also they have said.
Yes, para 6.
Para 6 it is clear.
Yes. Therefore, it is for your lordships to decide on such. But this is the latest instruction.
This contempt petition, contempt application was filed.
And only one submission in reply. And your lordships have been pleased to observe in the last order that the requisition.
You please hear this order. Alleging willful disobedience of the order and direction issued by this court in WPA P 301 of 2023 dated 15/6/2023. The court also took note of the earlier orders passed in WPA P250 of 2023 dated 13/6/2023. The operative portion of the direction issued in the order is as follows. Please quote para 6 of the order dated 21/6. The learned advocate appearing for the contempt applicant had elaborately referred to the various paragraphs of the order passed in WPA P301 of 2023, dated 15/6/2023, the order dated 13/6/2023 in WPA 250 of 2023, and the order passed by the Honorable Supreme Court in special leave to appeal in special leave petition C number 12294 of 2023 dated 20/6/2023. It is submitted that a cumulative reading of all these three orders will show that the time was the essence of the orders passed by this court, and the other two aspects being conduct of free and fair elections and to preserve the purity of the election process. It is submitted that these were the broad parameters which had weighed in the mind of this court while passing the order dated 13/6/2023 and 15/6/2023, which orders have been upheld by the Honorable Supreme Court. It is submitted that the turn of events it is submitted by the learned advocate for the applicant that the turn of events will clearly show the supremacy of the State Election Commission has been surrendered, and the purity of the election process has been compromised thus far and is likely to be compromised further. Therefore, the learned advocate for the applicant seeks for renewal of the prayer made in the first writ petition, namely WPA 286 287 of 2023, wherein they sought for an independent observer to be appointed by this court, and it was suggested that such an independent observer can be a retired judge of this court. The learned senior advocate appearing for the State Election Commission had Election Commission, after referring to the order passed by the Honorable Supreme Court dated 20th June 2023, submitted that on 22/6/2023, they have requisitioned the 8,000 companies, requisitioned adequate central forces in addition to the 22 companies already requisitioned. And out of the same, 315 has been sanctioned by the central government, and the remaining will be also done shortly. Therefore, it is a submission that there is no willful delay on the part of the State Election Commission in compliance of the orders passed by this court, and a prayer has been made to drop the contempt proceedings. Further, with regard to the observers, it is submitted that 273 Class 1 officers of the West Bengal State Service and 22 IAS officers have been nominated as observers. And the officers will discharge their duties diligently. The learned Additional Solicitor General appearing for the Union of India on instruction submitted that that orders have been issued by the central government for deployment of 315 companies for the 2023 Panchayat election, which is higher than what is provided for what was provided in the 2013 election. After we have heard the submission for the on behalf of the learned advocates appearing for the parties, we are of the view that in order to decide as to whether there has been any willful non-compliance of the directions issued by this court in its order dated 15/6/2023, which in fact was ancillary and supplementary to the earlier order dated 13/6/2023, we are of the view that affidavit needs to be filed by the State Election Commission. A crucial question would be as to whether the submission made on behalf of the State Election Commission that there is no willful delay on the part of the Commission, as they have complied with the orders on 22/6/2023. Soon after, the special petition filed by them was dismissed by the Honorable Supreme Court on 20/6/2023. The question would be as to how the delay has to be computed. As observed in the order dated 15/6/2023, the said order was in continuation of the earlier orders dated 13/6/2023, in which also timelines were fixed. Therefore, the order dated 13/6/2023 for all purposes stands merged with the order dated 15/6/2023, and both these orders stand merged with the order passed in this contempt application dated 21/6/2023. Therefore, the court has to consider the cumulative circumstances to examine the conduct of the State Election Commission as to whether there was any willful disobedience of the order and directions issued from time to time, or was there any attempt to make the order unworkable at different stages of time. This issue cannot be decided without an affidavit being filed by the State Election Commission. So far as the direction issued to the central government is concerned, we find the same has been complied with pursuant to the requisition made by the State of West Bengal. And in the assessment of the Ministry of Home Affairs, 315 companies would be adequate, and it would be more than, and it is higher than what was provided in the 2013 election, which we had indicated in our order dated 21/6/2023. Needless to state, as emphasized by this court time and again, that it is the assessment of the State Election Commission which is paramount. In fact, the court used the expression that the State Election Commission should make an honest assessment. Therefore, if according to the State Election Commission, 315 companies as deployed by the Central Commission is not adequate, but then the State Election Commission shall not fight shy to make additional requisition to the central government. This observation is made after taking note of the submissions made on behalf of the State Election Commission, that the Commission will do all within its means to ensure free and fair elections and to preserve the purity of the election process. It was also submitted on behalf of the Commission that individual grievances are before this court, being heard and decided by the learned single benches. However, we had pointed out to the learned senior advocate appearing for the appellant that even today, before the regular court, there were 2 writ petitions which were filed as public interest litigations. And in one of those writ petitions, it was reported that 273 seats in in canning one block have remain uncontested, and it is the voters who have come to court to say that they have got a right to choose the candidate, and a prospective candidate cannot be prevented from filing the nomination, and that the State Election Commission has not taken any proactive step in this regard. A direction has been issued in the said petition to the State Election Commission for their response. Given the totality of circumstances, and that not only the regular bench of this court, but two single benches and one another the division bench are all being engaged in matters concerning the elections concerning the ensuing Panchayat election. Therefore, we are of the view that strict monitoring is required to be done in the matter, for which affidavit has to be filed, after which the court will consider as to whether there has been any willful disobedience of the order and direction issued by the court in all the three orders and such other matters. Full stop. With regard to the appointment of observers are concerned, since the court in its initial order, in its first order dated 13/6/2023, declined to accede such a prayer, and in the present proceedings, a prayer has been made to renew the said prayer, such a request can be considered only after an affidavit is filed by the State Election Commission in this regard. We expect the State Election Commission to answer to the prayer on merits without raising any technical objection in this regard, as we have observed that the orders dated 13/6/2023, as we observed that the orders passed by the court from time to time are incidental and ancillary to each other, and the object behind passing such orders is to ensure free and fair election and to preserve the purity of the election process. We direct the State Election Commission to file their affidavit covering all the above aspects by 27/6/2023. Let the matter be listed on 28/7/2023 at 2:30 p.m.
28/6. It has
Sorry, 6/6/6. 27/6. 28/6. Sorry, 28/6 at 2:30 p.m.
Millard, only one thing, Millard, if I may make submission, Millard. If I'm not, Millard, wrongly heard, Millard, we have already, Millard, requisition for 485 today itself in course of hearing.
Okay.
Kindly be required.
Mr. Dattu Leonard, senior advocate appearing for the State Election Commission, submitted that he has been given instructions from the Commission that while the hearing was proceeding in the matter, additional deployment has also been sought for.
Of those 485, 822 minus 315, 485. For the 485, another letter has gone while the matter was going.
Another 485, what is it? Companies has been.
Or your Lordship may kindly consider, Millard, the recording in this way. Balance 485.
The balance 485 companies have been requisitioned. This submission is placed on.
315 in addition to
Of CRP.
315 companies in addition to 22 already deployed. That has been to be recorded. And my instruction may be kept on record.
We have not specifically recorded that because it's a personal letter. But of course, the last line says, please inform the court.
Yes.
One more sentence. The learned additional Solicitor General has also produced the copy of the written instructions given by the director within bracket PERS bracket close Ministry of Home Affairs dated 22/6/2023, wherein it has been stated as follows. There are 3, 5 and 6. Oh, no, 5 up to 7.
And the instruction is taken on record.
Yes, the above referred written instruction is taken on record. It is part of the order deemed to have been taken on record. Yes, sir.
রেকর্ড করেছেন তুমি।
In between you add, sir. The learned advocate appearing for the applicant submitted that an anomalous situation has arisen wherein large number of withdrawal of nominations have taken place, and the figure and the astronomical figure is 20585.
Oh, wow.
Full stop. The State Election Commission, while filing their affidavit, shall also address this aspect or this aspect of the matter, as in several cases this has been raised by various petitioners.
Milord, one more thing, Milord. I'm so sorry, Milord.
No problem.
My officer says that possibly, Milord, your lordships are of the view that observers would be appointed. In fact,
No. With regard to the prayer, he wants to renew the prayer. Without hearing you, we will not do that.
not on that aspect, Milord. The figure that I have placed before my lord, that WBCS and IS
Yes.
officers, they have already been deployed.
Yes, yes, that we are.
Right.
So let it come next Wednesday.
Right.
Well,
Yes,
with
what is
regard
the-
to the
Video.
second contempt, my lord,
Yes.
the videography, shall I come back at 2 o'clock, my lord?
No, 2 o'clock is not possible. You please make use of.
Fair enough, my lord.
What is your instruction on that videographing, sir?
Milord, ওতে কে appear করছে?
My lord, I am on a very limited point, my lord. Lord, will kindly take page 30 of the impugned order, my lord. Of the order, my lord, where, my lord, they are in
Milord,
violation.
may I only say one thing, Milord, instead of wasting your lordship's time, could this matter be taken up, Milord, maybe on Monday? In the meantime, may I take instruction? But the only instruction that I'm spontaneously got is that we have already written to whoever is concerned. But Milord, with half-baked knowledge, Milord, I don't want to, Milord, address the court. Kindly take it up as the first matter on Monday, or whenever your lordship feels, Milord.
But only,
We just here, here is.
only thing is, well, lordship was pleased to observe, my lord, with regard to videography, my lord, a specific submission was made on our part, my lord, that, my lord, where where CCTV coverage is not possible, videograph to be done
That is,
from the
we have
date of,
directed
yes,
in the first order.
first order, my lord. The second order, my lord, was assailed before the Honorable Supreme Court. Lordship will kindly take the
No.
last line of the
Supreme Court, both orders.
both orders. And the
Yes,
last
both
line, my lord, last line of that order, my lord, I will only take the second last paragraph, my lord. In the circumstances, we find that the order of the Honorable High Court would not call for any interference in these special leave petitions, and we are also not inclined to interfere with any other direction issues. So this direction which
Is
the lordship,
affirmed.
that is covered.
That, Mr.
That is
Dattu-
covered,
Dattu has said.
Only
They have
thing
to
is, my
comply
lord,
with the order.
I will just give you a very selective small figures, my lord. Admittedly, 61,636 number of booths.
61,000.
636.
Minimum 4 cameras.
I exclude, my lord, 1,000 booths, my lord, where there are uncontested things that has happened, my lord. 60,000. If your lordship goes by the round figure of
That is
60,000, my lord,
contested booths will be 61,636.
total 61. 636, my lord. If there are in 60,000 booths, if there are minimum of 4 cameras, my lord, minimum. 2 at the gate, my lord, and 2 inside, my lord, excluding the place where their actual polling is to be done, my lord. 240,000 number of cameras, my lord.
Is required.
That can be
Required.
requisition.
No,
Requisition has to be issued, my lord, and government has to advertise that. Somebody has to provide, my lord, because election commission, my lord, election commission.
No, direction has been issued. Non-compliance is contempt. That's why you are here. We'll ask them to, for the figures. That's it.
During nomination,
Sir,
there was no video.
Wait. Either you address the court.
I'm sorry, my lord.
What is his concern? Your friend's concern.
My lord, I am instructing that regarding during the nomination, there was, my lord, direction that was not complied.
So your contempt is pending.
Yes,
Let them file an affidavit here. Also.
fair enough, my lord. We'll come back on, since Mr. Dotto says that he will come back
We
with
have heard
instructions
also.
on Monday,
That
my
is-
lord. We'll come back on Monday.
No. We come back on Wednesday.
Grateful.
8:41. We have heard so and so. It is submitted by the learned advocate appearing for the applicant that the orders and directions issued by this court on 13/6 and 15/6, 2023 have been affirmed by the Honorable Supreme Court. And that would mean that all directions issued should be scrupulously complied with. It is submitted that leaving aside the uncontested booths, there will be roughly about 61,636 booths in which elections will have to be held. And at least a minimum of 4 cameras are required to be installed. And it is submitted that it is not clear as to whether requisition has been made during the filing of nomination, the order and direction issued by the court for installing was not complied with.
Grateful.
Was not complied with. We direct the State Election Commission to file an affidavit with regard to these issues. And while doing so, it should be borne in mind that all directions issued by this court in the 2 earlier orders have been affirmed by the Honorable Supreme Court. Let such affidavit be filed on or before 27/6/2023 and list this contempt application on 28/6/2023 at 2:30 p.m.
Deeply obliged, my lord. Well, I'm sorry for my juniors' demeanor, my lord. Just exuberance of youth, my lord.
Oh, the thing is,
27
you can't hear.
yes.
So, art of